Welcome to the Explainer. Today, we're diving into a document that is an absolute must-read if you are operating anywhere near the global technology, manufacturing, or creative sectors. We're unpacking the 2025 China Intellectual Property Protection Status Report. And let me tell you, when you look closely at the data in this report, you quickly realize just how critical this roadmap is. For a really long time, the narrative surrounding China's IP landscape has been, well, fraught with complexity and, frankly, a lot of outdated assumptions. But 2025 represents a massive, undeniable pivot. We're no longer just looking at a system that's trying to catch up. What we are seeing is a system actively transitioning from basic protection to actually fueling strategic, high-level innovation. Whether you're a foreign investor, a tech innovator, or a corporate legal strategist, understanding this evolution is absolutely vital to your survival and your success in the world's second-largest economy. So let's break down exactly what this new landscape looks like using the direct data and the case studies provided by the national authorities. Okay, let's dive into this. Here is our roadmap for today. First, we'll look at the 2025 innovation landscape. Second, we'll see how courts show their teeth. Third, we'll examine swift administrative action. Fourth, defending tech and brands. And finally, we'll wrap up with the new rules of play. Starting with Section 1, the 2025 Innovation Landscape. Now, 2025 is a deeply significant year because it marks the official conclusion of China's 14th five-year plan, and the overarching theme of this entire period, a definitive shift toward high-standard IP protection. The standout metric here is 82.81. That is the National Social Satisfaction Score for IP protection, measured on a 100-point scale. Now, you might be wondering, why does a satisfaction survey matter to my IP strategy? Well, this score reflects the actual on-the-ground sentiments of various market entities, and that includes both domestic and foreign businesses. Crossing that crucial 82-point threshold sends a clear signal that the business environment has highly stabilized. It means that when companies pour money into R&D and when they bring their proprietary tech to the market, their expectations of actually being protected are being met. It's a foundational metric, really, proving the ecosystem is giving operators the sheer confidence they need to invest heavily in the region. And you know, that confidence translates directly into the hard data. We're currently seeing 16 high-value invention patents per 10,000 people. And I really want to emphasize that phrase, high value. In the past, observers rightfully criticized the system for churning out a massive quantity of low-quality or essentially junk patents just to hit government quotas. But this metric, this represents a huge strategic pivot. The system has shifted its focus to generating commercially viable, highly technical, and strategically important innovations. This dedication to quality over sheer volume has officially propelled China into the top 10 of the Global Innovation Index, or GII, in 2025. That is an incredibly fast movement for an economy of this massive size. For a tech innovator, the takeaway here is crystal clear. You are no longer just trying to protect your IP from imitation. You are now competing in a market that is aggressively generating its own world-class, highly protected innovations. Moving right along to Section 2. Now, what's really interesting about this next part is how the courts are actually enforcing these high standards. Let's look at courts show their teeth. In 2025 alone, national courts received over 473,000 new first-instance civil IP cases. That is a staggering, almost unbelievable volume of litigation. But the really crucial takeaway here isn't the new cases, it's the clearance rate. Over 460,000 cases were concluded. Think about that from a strategic perspective. An IP right is completely useless if you can't actually enforce it in a timely manner, right? If a court system is so hopelessly backlogged that it takes 5 years just to get an injunction, your product lifecycle might literally already be over by the time you win. So this incredibly high clearance rate is absolute proof of a highly efficient, specialized judicial machine. It shows that the courts have the capacity, they have the specialized tribunals, and they have the technical investigators needed to process incredibly complex IP disputes rapidly, providing that much-needed, timely relief to rights holders. To really grasp how these courts are applying the law on the ground, we need to look at specific strategic micro-narratives. Take the landmark NP1154 corn seed case. Now, you might be asking, corn? Why on earth are we talking about corn in an IP explainer? Well, because agricultural technology and seed sovereignty are absolute top-tier national security priorities right now. In this specific case, a company illegally produced and sold 7 varieties of hybrid corn seeds, and they used the protected NP1154 parent variety without any permission. The court stepped in with a remarkably rigorous defense of this agricultural tech IP. And here is where the teeth really, truly show. The court didn't just award a standard compensation. Standard compensation basically just pays back the fundamental economic losses the rights holder suffered. No, they went further. They applied punitive damages. Punitive damages are designed not just to compensate you, but to actively punish and deter severe malicious infringement. Because the infringement in this case lasted for 5 whole years, was clearly intentional, and covered a massive planting area of over 8,200 mu, the court applied a 1x punitive multiplier. This resulted in a historic total payout of 53.5 million RMB. For business leaders looking at this data, this is the metric that changes everything. It proves that the cost-benefit analysis for IP theft has fundamentally shifted. Infringement is no longer just a cost of doing business. With punitive damages on the table, it is a catastrophic business-ending risk.
All right, let's look at Section 3, Swift Administrative Action, because it's not all just happening in the courtrooms.
Beyond the courts, local and national regulators are acting as rapid response units. There is a massive whole-of-government approach dedicated to cleaning up the market. Just look at these operations. Protect IP, executed by market regulators, handled 37,000 cases involving 674 million RMB. Then there's SwordNet 2025, which aggressively targeted the digital space, shutting down nearly 3,000 pirated streaming and copyright-infringing websites. And Longteng 2025 saw Customs seize 33,000 batches of suspect goods right at the borders. For rights holders, I cannot stress this enough. This administrative track is incredibly valuable. It's often faster, much more cost-effective, and way less procedurally burdensome than dragging yourself through a full civil lawsuit. It allows you to quickly halt infringement and seize counterfeit goods through direct, swift government intervention.
But administrative action isn't just for knocking off counterfeit sneakers or fake handbags. It extends to highly complex tech disputes too. Take the HEVC Standard Essential Patent, or SEP case. This dispute involved the global H.265 high-efficiency video coding standard. That is technology that's very likely inside the device you are using to follow this explainer right now. Access Advance LLC claimed a Chinese firm was implementing their standard without a license. Now, instead of entering a multi-year, multi-jurisdictional litigation war, which easily could have resulted in global injunctions and massive supply chain disruptions, this was handled via rapid administrative mediation by the Guangdong provincial authorities. They brought both parties to the table, clarified the fair, reasonable, and non-discriminatory, or FRAND, licensing principles, and facilitated a settlement. And this brilliantly illustrates how administrative bodies possess the sophisticated technical and legal expertise required to step in and resolve highly complex international patent pool disputes swiftly, entirely without lengthy litigation.
Which leads us right into Section 4, Defending Tech and Brands. Let's see how these mechanisms are specifically protecting consumer brands and critical software infrastructure. This broader economic shift we've been talking about is perfectly illustrated by Beijing Customs launching precise, targeted services for cultural brands that are going global. A great example of this is Pop Mart, the brand famous for their highly collectible designer toy blind boxes. This is a prime example of China stepping up to protect its own domestic cultural brands as they expand overseas. China is no longer just the world's factory floor, it is increasingly the creator of globally recognized, deeply loved IP. And the enforcement mechanisms are actively evolving to protect that outbound value. So what happened with Pop Mart? Well, the Pop Mart Customs bust was an absolute masterclass in unique interagency cooperation. It wasn't just Customs acting alone in a silo. It was a joint operation combining Customs, market regulators, and the police. Together, they meticulously mapped out the entire counterfeit manufacturing supply chain and the export routes. Ultimately, they seized 114,000 trademark and copyright infringing items, saving the enterprise over 200 million RMB in potential losses. The so what here is huge. This proves that cross-departmental data sharing is highly, highly effective. The system is proactively intercepting counterfeit exports before they can even hit and poison foreign markets. If you're a brand owner, registering your IP with Chinese Customs is, without a doubt, one of the highest ROI defensive moves you can possibly make.
Now, over in the digital realm, the Zhong Mo Song software copyright case really showcases the criminal teeth of the system. Between 2018 and 2023, Zhong and others systematically cracked the physical dongles, the network locks, and the technical protection measures of multiple engineering management software programs. Basically, they bypassed the DRM and sold the pirated software for profit. The response? The court handed down heavy 6 to 7 year prison sentences and fines up to 4 million RMB, while also forcing them to pay 4.9 million RMB in civil compensation. For enterprise SaaS and software engineering companies, this is a massive flashing signal.
The state is actively utilizing severe criminal penalties to protect the technical measures that safeguard your core technological innovations. Let's move to our final segment and see how this all builds together. Section 5, the new rules of play. 2025 wasn't just about enforcement. It was a year of profound legislative overhaul. Let's map out this chronological rollout. In May, specific rules on handling foreign-related IP disputes took effect, completely standardizing and clarifying the playing field for international entities. Then, in June, the revised seed law came into force, which directly led to those severe penalties we saw in the corn seed case earlier. And then, very significantly, in October, the newly revised anti-unfair competition law was enacted. This one is absolutely vital. Anti-unfair competition is quite often the catch-all mechanism used to prosecute trade secret theft, data scraping, and malicious commercial practices that standard patent or trademark law might actually miss. These new laws have completely reshaped the playing field. And the legal framework isn't just reacting to the present, it is actively future-proofing itself for tomorrow. Effective January 1st, 2026, the patent examination guidelines have been explicitly revised to address the totally unique IP challenges of artificial intelligence and quantum information. We're also seeing new, highly specific regulations implemented for live streaming media copyrights, a booming industry that has historically been a bit of an IP Wild West. The region is racing to establish the rules of the road for the next century of technology, ensuring that as new industries rapidly emerge, robust IP protections are already waiting for them. So what does this all mean for you? Well, it brings us to the ultimate question you need to ask yourself and your executive team today. Is your company's IP strategy ready to survive and, more importantly, to thrive in an environment characterized by punitive damages, high-efficiency courts, and rapid, multi-agency administrative enforcement? The days of treating China merely as a high-risk jurisdiction for IP theft are officially over. It is now a highly sophisticated, rigorously enforced legal landscape. If you haven't audited your IP strategy, updated your customs registrations, or reviewed your compliance with the new anti-unfair competition law, the time to do so is right now. Thank you so much for joining me on this deep dive into the 2025 China IP Protection Status Report. Keep learning, stay focused, and I'll catch you on the next explainer.